All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Harvey L. J., Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Great to see everyone. As I believe you know, we are sitting officially as the 5th District Court of Appeal, and I have the honor of being here. My name is Harvey J. With two of my colleagues, fine colleagues from Daytona. To my right is Judge Rand Wallace, and to my left is Judge Adrian Soud. Both of these good men were longtime trial judges, so they understand what courtrooms are like, and this is no surprise to them to be in a courtroom. So I'm thankful to have them with me today. Why did I say official? I said official on the front end because this is a court of law. This is not a moot court event. This is not a mock trial event. This is real business of the 5th District Court of Appeal. And why does that matter? It matters because I'm going to run this courtroom like a courtroom. Just to tell you what our plans are, we have 3 cases on the docket today. After the first case, we'll take a short break, probably 10 or 15 minutes, and then we'll go through the last 2 cases. I understand we have some students with us today from Forest High School, and great to have you guys. And Kathy Carr, Ms. Carr is the teacher from Forest. We will also give you an opportunity after we're done to ask questions. But not about the case or cases. Judge Soud and I had not a bad experience, but had an experience at JU not terribly long ago, and a very persistent young man who was just obsessed with asking us about one of our cases. And we politely said, we can't talk about the case, and then he asked again about the case, and we said, no, we can't talk about the case. And then he tried a hypothetical about the case, which was very ingenious of him. But he finally figured out we couldn't talk about the case. So, but we will take some questions, but not about the cases. I would ask before we get started that you turn off any cell phones or electronic devices. I would also ask that if you have any business to be done that would cause you to leave in the middle of this oral argument, I would ask that you leave now. Because once we get started, I would appreciate, I know the judges and the advocates would appreciate you staying with us. Because it's disruptive to those that are trying to listen, as well as those that are speaking, if you were to leave during the event itself. We will take a break, so if you do have business you need to attend to, there will be a 10 to 15 minute break after our first case. Let me pull up our schedule here this morning. Anything further, Judge Soud or Judge Wallace, for the court? We will start with our first case of the day, Beer Warriors United versus Florida Department of Transportation. That case number is 2024-0958. Is counsel for the appellant?
Yes, Kevin Lamontagne.
All right, sir, you can come to the podium. For everyone's benefit, typically the default in the appellate court is to reserve 5 minutes for rebuttal, but that does not have to be the case. We've had lawyers that don't reserve any time. We've had lawyers that reserve less than 5 minutes. So what say you?
Your Honor, I think I'll reserve 3 minutes.
3 minutes. It's good to be out of the ordinary. So our wonderful marshal is here with us today. He'll be our timekeeper. So when you're ready, please proceed.
I'm attorney Kevin LaMontagne, the attorney for the appellants, Bear Warriors, Derek LaMontagne, who's also my nephew, Brian White, and Sweetwater Coalition. This is a case where the ultimate thing that this court needs to decide is whether the ultimate legal conclusion of the district is as or more reasonable than the ultimate legal conclusion that was rendered by Judge Early, the administrative law judge. And so I thought to myself, well, why don't we look at the way each of them arrived at that ultimate conclusion? And if it looks like the process by which they arrived at it, one was more reasonable than the other, then I think it's likely that the ultimate legal conclusion reached by that side would be more reasonable.
You talked a lot in your briefing about the constitutional amendment and the amendment dealing with deference to the agency. But you would agree the agency still has the right, the statutory right, the constitutional right to make a legal determination.
The agency has the right to make a determination, but the question before this court is their ultimate legal conclusion, in this case, more reasonable than the others. Now, they have to follow the law, and there are requirements specifically if they're going to overturn findings of fact. It's very difficult to do. Conclusions of law, there's certain requirements, and under the administrative code, if they need to specify, they need to state with particularity particular matters if they're going to when they render that conclusion. And
let me ask you about a case, and I didn't see it in your briefing. It was raised by the St. Johns River Management appellee. It's Murciano, which is the first DCA case. I didn't see that you dealt with that, which goes in some detail about the constitutional amendment. And let me just read you something from that opinion, 1287. And I just want to know if you agree with it or not. And I know the first district is not our court. It used to be my court, but I'm sitting here for the fifth today. It says the agency gets to determine what legal conclusions to reject and what to accept from the ALJ's, the administrative law judge's recommendations. Is that true?
They make that decision, but ultimately that is true. They do have the right. I mean, they have the substantive that was raised, I think, in Mr. Peoples' brief. He was talking about substantive jurisdiction. Naturally, they have substantive jurisdiction over this. The question is, this issue still is whether their ultimate legal conclusion is as or more reasonable, and that's something that this court has to ultimately decide. So yes, they have the right. They have the right to state what they want but they then need, when they come before this court, there's not going to be any deference to them just because they're the district. Okay, and even on issues of policy, the same thing. I mean, if they reduce a policy to writing, I don't want to spend too much time on this now because there actually wasn't any specific policy that they raised in this case as a grounds, unlike the case which.
Well, this is important to this judge. I can't speak for the other two judges, but you did bring up the Constitution.
Yes.
And Murciano deals with the Constitution.
Yes.
It deals with legal, the ability to reach conclusions of law. Let me read you another quote from Murciano. This is on the bottom of 1287, top of 1288. It says, the conclusions of law in a final order are the conclusions of the agency, not the ALJ. Would you agree with that as well?
I don't agree. I don't agree that they're the ultimate arbiter on the conclusions of law, whether it's reasonable or not. Obviously, they are going to reach their own conclusions of law, and they did in this case. And it's the opposite of what was reached by the administrative law judge.
So what we agree on, though, is they have the right to reach those conclusions. You just think they were wrong.
Yeah, and that's ultimately the test here. This court needs to decide whether the ultimate legal conclusion that they reached is at least as or more reasonable than the ultimate legal conclusion reached by the administrative law judge. So yeah, they have the right to do that, but that's why we're here, because that's what this court is going to need to do, is going to need to compare the ultimate legal conclusions and determine which is more reasonable. And there's going to be no deference given to them on that particular part of it. This court anew in reviewing it, because it's a statute.
When you say deference, you mean that it's a de novo review?
Yeah, de novo review. A de novo review is what I mean. It's a de novo review on the issue of statutory construction.
The district did not reject any of the ALJ's factual findings, correct?
I don't really think so. I don't think they said they did. I don't think that's really a big issue here.
Well, if you don't think so, then please tell me, is there any...
No, I'm not going to say they did.
Wait a minute, let me finish my question, please. I'll ask the question, you give me an answer, I won't cut you off, okay? So, were there any specific findings by the ALJ that the district rejected?
Not to my knowledge.
Okay, thank you.
But Judge Early's approach on this was he looked directly at the wording of the statute. And this court, as an administrative law judge, as for other courts, like even administrative law judges, that's their special expertise, is to analyze the terms of a statute, contract, whatever.
Are you saying we have an obligation to defer to a non-Article 5 judge, an ALJ?
No, I'm not saying that at all. This court now, and there are some cases, and I think they were cited by the district originally, that suggested that the courts need to defer to on that. I don't agree with that at all. At this point, this court's the ultimate decider. You're the one that's going to decide. It's without deference to anybody. You review this anew.
So your contention then is that the determinations of the administrative law judge and that of the department come before the court on equal footing?
Yeah, and this court needs to decide which is more reasonable. And if it was not as a more reasonable, the ultimate legal conclusion the district reached, then it can't stand. It needs to go back to what the administrative law judge said. But that's up to this court to decide. And that's why I look at, first and foremost, the statutory language. And I know that they put a lot of focus on that 1-800-Atlantic developers case. And, that's a great case. When I read through it, I think this is a great case. If you analyze what it really is saying, it's a perfect case. But one of the issues about the case is it was under a prior statute where it was not just environmental benefits, but it also included other societal benefits.
Let me ask you about 1-800-Atlantic because there is a quote in the St. Johns River Water Management brief saying what they contend is a truism from that case, but and I quote, and adverse impacts for one factor do not necessarily mean that the project is not clearly in the public interest. Do you agree with that?
That's absolutely correct. I mean, it's possible. You've got 7 factors. And, some of them may not have any facts that pertain to them at all. Others may have facts. Some may be neutral. Some may be positive. Some may be negative. There may be varying degrees of positivity and negativity under each of those factors as to the facts. And that's why it goes before an administrative law judge, because he has an expertise in dealing with the public interest test and weighing those kind of factors.
So you may be saying the same thing as the St. Johns River Water Management brief, but they go on to say, again, referencing 1-800-Atlantic, all of the 7 factors must be collectively considered to determine whether, on balance, a proposed project satisfies the public interest test.
It's definitely a balancing test, and I believe that Judge Early explained it very well in his amended recommended order, because he said it's not a mathematical test. This is a qualitative thing. And it's not like you're going to start adding this up and adding that up. But that case then, the fact that, the fact that there can be an adverse impact and still be clearly in the public interest is also good reason for this court to say the mere fact that there are no adverse impacts, it could also not be clearly in the public interest. Because these cases are all over the place, and there's varying degrees on these various factors. And you're not going to be able to look at it and say 2 out of 3 or 3 out of 5, and look at it that way as if it's mathematical. You need to look at how both sides reviewed it, and did they actually assert, did they actually have support for what they want to rely on? And I think the difference between the way that the administrative law judge handled this, and the way this court I'm sure will handle it, and the way that the St. Johns River Water Management District handled it, is they put too much emphasis on like that WWALS case. They find a case and it says, okay, there were no adverse impacts under this case. And it also met all the simple regulatory requirements. Therefore, it's clearly in the public interest. Well, I don't think this court wants to adopt that as the holding of this court, because these cases on the public interest test are all over the place. And you can have there's varying degrees of negative and positive and 7 factors, and the possibilities are infinite. So, for them, yes.
You made much of the Kanner case, K-A-N-T-E-R. It was a case I was actually on the panel of when I was in Tallahassee. And you say that's every reason to reverse what happened here. Why does Kanner win the day?
You know what? Actually, I don't think Kanner wins the day.
Okay.
That was my initial brief. I believe the one that actually wins today is.
So you disavow Kanner?
No, not that I disavow it, but I don't think it's exactly on squares on all fours with this case. I think a much better case for this court to look at is the Florida Power Court versus Department of Environmental Regulation, because that was a substantive case, and it's very clear how in that case what was done in order to overturn the administrative law judge, and they specified a particular policy. Also said, actually, were very specific when they did that as to the various, how it applied, actually took that policy and then talked about the various factors of the public interest test. It applied it to it. And that's what's completely missing from this case. You don't have an explanation like that, where you had the agency say, okay, we have this policy, and this policy mitigates this, goes this way, and we're going to take that and we can overturn the administrative law judge with herbaceous wetlands versus forested wetlands. And they drew that distinction. And they said, it's it's up to them. They have the right. That's policy determination. Now, the only difference between that case and now, I guess, is that in this case there really was no specific citation of a policy where they could have said maybe they had some discretion. But I would also submit, and I would agree with probably the dissent on that Florida Power Court, where the dissent said back in that case that they should really bring the factual determinations to the hearing officer and let him analyze it and bring that all before him. I think that makes a lot of sense. Because I don't think it should be like an ambush where, like, after the fact, an agency comes in and says, "Oh, by the way, we have these policies. We've never said anything about them at the trial, but okay, now after the fact, we're going to substitute our judgment, and we are going to overturn the administrative law judge."
What precedential effect does a dissent have? for our.
No, it doesn't. Although one of it is kind of another. It's interesting for another reason as well, because in that case, it was the Department of Environmental Protection, which interestingly was the one looking out for the environment more than the. And that was part of their case. They were actually trying to have a permit denied because they felt it was going to adversely affect the environment. In this case, it's the Water Management District, which is supposed to be looking out for the environment, and they didn't. But I think that the reason that dissent could have some bearing today is because now, since this case, there has been the constitutional amendment, which talks about how there's not supposed to be any deference. So to me, that indicates that if the district had wanted to raise like a policy issue or that.
Well, let me read you again from Murciano that deals with the constitutional amendment, and just ask if you agree with this. Synopsis. It says the adoption of Article 5, Section 21, which is the amendment we've been talking about, was an important shift in Florida law, but it means what it says. Article 5, courts and administrative hearing officers are to make de novo legal conclusions without deference to an agency's preferred interpretation. But then it goes on. It says it does not prohibit an administrative hearing officer from taking any action in furtherance of an agency interpretation, and it does not upend the Administrative Procedure Act, which talks about an ALJ issuing a recommended order and the agency issuing a final order. You would agree with all that?
Well, I'm not quite sure I understand by what you're getting at, but
My point is, it was a sea change of sorts, but it didn't change the edicts. The words of Murciano, it didn't append the Administrative Procedure Act, other than in the area it did.
No, I don't think it upended the Administrative Procedure Act, but I think what made it clear was the administrative law judge, and if you read the way he analyzed the case, he did it much like first at 1-800-Atlantic. He looked at it from a statutory perspective, and he.
And Counsel, you're in your rebuttal time, but part of that was because of this judge. So why don't we give him another minute of rebuttal time if you want it.
Okay.
If you want to keep on, you may.
Okay, just go for a minute. The agency doesn't have. The deference is to an administrative law judge has. We'll say not deference. An administrative law judge reviews de novo, and this court reviews de novo. I don't. That's not really the situation with that amendment to the Constitution does not give the agency like a de novo review. They have a right to try to substitute their legal conclusion if it's as or more reasonable, but ultimately then that comes before this court, and this court then decides. So, okay.
Thank you. So you'll have 2.5 minutes for
Thank you.
Counsel?
Good morning. May it please the court, Mark Peoples for the Florida Department of Transportation. With me at council's table is Jessica Quiggle. Ms. Quiggle is representing the St. Johns River Water Management District. We intend on roughly splitting our time this morning, but we're at the court's disposal, so if the court wants to discuss things with the permitting agency as opposed to me, I'm happy to yield the floor.
Which will be fine. This judge has no problem with you splitting your time. Don't feel duty bound if you don't need to use every minute of that time, but I leave that to both of you. But please proceed.
So I know the court knows this, but for the benefit of the law day participants, the department has a project to build a new interchange, on-ramps, off-ramps, that kind of thing, at the intersection of I-95 and the Pioneer Trail Road in Volusia County. And that interchange project is intended to alleviate congestion and to aid in hurricane response and evacuation. In connection with that project, the department applied to the district for an environmental permit. The appellants opposed that interchange project and challenged the permit. That challenge was heard by an administrative law judge. The administrative law judge made factual findings. Those factual findings are not challenged, not by me, not by Ms. Quiggle, not by appellants. Among those factual findings are that this project will not adversely affect the environment. The interchange project will not adversely affect Spruce Creek. The interchange project will not adversely affect wildlife. In fact, the administrative law judge went further, said not only will the interchange project not adversely affect the environment, the interchange project will actually aid the environment.
So why did the ALJ reach a different result?
My understanding is that the administrative law judge reached a different result because the administrative law judge reads the clearly in the public interest standard set by statute to require some extra textual benefit. And although the department provides extra benefits, I guess the ALJ found that that wasn't quite enough. In my view, even if you accept appellant's argument that an extra benefit is required.
So it is, again, for this judge, there's the test not contrary to the public interest.
Right.
And then the test clearly in the public interest.
Yes.
And as I understand it, the same 7 factors apply to both of those.
Yes.
Is there a difference?
Yes.
What's
Yes.
the difference?
Well, there are 2 competing interpretations of what that difference is before you. According to the appellants, some extra textual environmental benefit is required. According to the district, the test requires a greater quantum of evidence to meet the reasonable assurance standard.
Where is that in the test?
It's got to mean something. And the district, I think that the district's interpretation is the better reading of the statute, if only because it doesn't add some ink blot to the statute. It doesn't require an applicant to guess what extra environmental benefit might be adequate for the issuance of a permit.
Is extra environmental benefit in the statute?
No, it is not. And that's our entire point. It does have to mean something, but to require something that's completely extra textual, as opposed to what the district's view, which is you have to meet the statutory criteria, but clearly in the public interest requires greater assurance. There's no guarantees. The statute doesn't require guarantees that the project will go according to plan. But by requiring greater assurance, that helps meet the clearly in the public interest standard without reading words into the statute that just aren't there.
So, if we were diagramming this out,
Please.
Greater assurance equals clearly? I mean, that's the way we get to clearly?
That's the district's interpretation, yes. But I don't think the court needs to reach that conclusion. I don't think, as far as I know, because they've apparently abandoned the Cantor argument,
That's what I heard.
the only real argument before the court is what does clearly in the public interest mean? In the department's view, even if you accept the appellant's view that clearly in the public interest requires some extra benefit, the interchange project provides extra benefits. The administrative law judge found, and this is unchallenged, that the interchange project will result in a 29% reduction in phosphorus loading to receiving waters. The administrative law judge found, and this is unchallenged, that the project will create a stormwater management facility that will treat stormwater for runoff purposes and will not only meet the 25-year storm level event that the rule requires, but actually exceeds the requirement by providing for the 100-year storm event. And finally, the interchange project provides environmental benefits because the existing wetlands that will be affected by the project are of, at best, moderate quality. The administrative law judge found that the mitigative measures called for in the project will more than offset any impact to wetlands. In the department's view, these are all extra benefits within the meaning of appellant's interpretation of the clearly in the public interest standard. So, in our view, it's not necessary for the court to reach the question of what clearly in the public interest means.
Well, but you're telling us extra benefits aren't required.
I agree. They're not required.
But then you're saying that wins the day. I'm trying to reconcile it.
Okay.
I hear you. I think you're saying if it's his test,
Yes.
you still got it.
Right. This is exactly right.
But
Sorry,
you're telling us it's not the test.
I'm telling you that I don't think that that is the test. But if the court disagrees with me, we still win.
But should the court address what is the proper test? Shouldn't we?
In my view, courts try and limit themselves to the questions that need deciding. And if this question doesn't need deciding because we prevail, we deserve the permit under either interpretation that's before you, I'm not sure that it needs to be decided here.
Well, I'm sorry. No, go ahead.
Please.
I heard your argument as to even under appellate standard we prevail. My ears were ringing with that's your alternative position.
Yes.
That's the alternative position, but the
Right.
primary position is
Primary
that
position
the
is that,
text does not support the extra environmental benefit required.
that's correct.
Okay, because I was with Judge Jay as far as seeking the clarification. I was
Right.
clearly hearing an alternative argument, and your suggestion that in deciding the case, because the alternative argument, even if the standard is not what you believe it to be, because the alternative still causes you to prevail, we can look over the statutory language and the perhaps improper interpretation of that language.
I think so.
That should,
Yeah.
I understand.
Yeah. And the reason why I'm hammering so hard on my alternative argument, you're right, it is an argument in the alternative, is because I raised it in the department's answer brief. It's not addressed in the reply brief.
Well, let me ask you this. If we do that, what about the next case?
If the court feels inclined that, I understand the court's role in providing guidance to bench and bar. And if the court feels strongly that bench and bar require guidance in this field and wants to write an opinion, then I would urge the court to adopt the district's view of the statute. Like I said, if only because it doesn't impermissibly read words into the statute that aren't there. That is our primary position, and I'm sorry if I confuse the court in any way in my emphasis here today. But again, I'm emphasizing this because I still haven't heard what they have to say about our alternative argument. They don't address it in the reply brief. They didn't address it in 17 minutes of oral argument. And so I'll be curious to hear what they have to say. But in my view, under either standard, under the districts, under the appellants, the department proved its entitlement to a permit, and the court should affirm. If there's no further questions for me, I'm at 10:30, and I'll like to yield the time to Ms. Quick. Thank you.
Thank you.
Good morning, Your Honors. May it please the court. Jessica Quiggle for the appellee, St. Johns River Water Management District. I would like to refer to as the district, if that's okay. This court should affirm the district's final order in this case because the district followed the plain language of the statute. The recommended order holds in footnote 6 that clearly in the public interest means the permit applicant needs to show something extra. And footnote 6 itself states that the permit applicant needs to show something not already required by rule. Extra is not in the statute. Footnote 6 relies on a case called Goldberg, which is a DOA case. Goldberg dealt with construction of a bridge where the applicant was applying for a different type of permit than the permit that's at issue in this case. In Goldberg, the applicant was seeking a sovereign submerged lands easement from the Board of Trustees of the Internal Improvement Trust Fund, where under that public interest test, public benefits are required, which makes sense because if you're seeking an easement from the Board of Trustees that holds submerged lands in trust for the benefit of the public, there should be some type of public benefit.
Let me stop you if I may.
Sure.
Ms. Quiggle. what is the standard? I mean, help us with the test.
With the
Because
quickly-
that's why we're here.
Sure. So it is.
We know it's de novo, but what is the test? What test do we apply to this case to independently evaluate?
So let me start with reasonable assurance, and that standard it's unique to environmental permitting. It's explained on page 2 of our answer brief, and it's also cited in the recommended order, and the record site is 3576, paragraph 127. So reasonable assurance does not require absolute guarantees that all the rules and criteria will be met. It just requires a substantial likelihood, and that's from the case law. So when the district is looking at permits, they're not starting at 100% to begin with because the projects have not been built yet. The district is reviewing plans. And once these projects are constructed, there can sometimes be a deviation from what was permitted in the plans. So reasonable assurance is a scale, and you're going to have a margin of error. So clearly in the public interest requires a greater degree of reasonable assurance than not contrary to the public interest. And
Why?
it's a higher standard, clearly in the public
I
interest.
think we all agree.
Okay.
And we all agree it's a higher standard. I would like to find that in the text somewhere, but it's not in the text, or it is in the text.
Well, we rely on DOA cases, which I understand are not controlling precedent on this court, but they can be instructive because they talk about how the agencies have applied the reasonable assurance and how they've gotten to clearly in the public interest. So let me go to...
And those cases, and I know you cite some of them in your brief, recognize it is a higher standard. And this higher standard is this greater quantum of evidence of goodness, I guess. I mean, I'm trying to figure out how best to verbalize it.
I can give you some examples from this case. In this case, all the district's rules required for nutrient reduction was a net improvement. That's in the record, that's in Judge Early's order. So theoretically, if a permit applicant came to the district for a permit, they could show a 1% reduction in phosphorus or whatever the water body is impaired for, and that would technically meet the rule because that's a net improvement. Here, FDOT showed a 29% reduction in total phosphorus. So if you look at the 1%, with the margin of error, you could have maybe after the project is built, 0.5% or 1.5% of the nutrient reduction that was called for in the plans. But when you have 29% reduction of phosphorus, that's a bigger margin of error, and the project is more likely, it's more certain that they're going to have a reasonable assurance that they're going to meet the rules. And another example, like Mr. Peoples pointed out, was the ponds. FDOT sized their ponds for the 100-year 24-hour storm, which is not called for under district rules. All the district rules require is ponds large enough to accommodate the 25-year 24-hour storm. So that was another greater degree of reasonable assurance that FDOT provided that it was going to meet our water quantity rules in this case. So those are examples here where FDOT has really gone above and beyond just meeting the bare minimum requirements of the rule. They've provided a greater degree of reasonable assurance that their project is going to be successful. And this is, I'm going to go back to WWALS, that's a Bram Cantor case from DOA. I'll quote it: demonstrating that a project is clearly in the public interest requires greater assurance that all permitting requirements will be complied with. Sable Trail, which was the permit applicant in that case, showed
Does the DOA judge cite to a case for that, or is that just the DOA judge?
He cites to another DOA case, but
Cites to another DOA judge.
We're not
and
aware-
nothing wrong with the DOA judges, but
we're not aware of any district court holdings
that was my
explain-
next question.
Yeah.
No district court cases, no Florida Supreme Court cases talking
Not that
about.
we're aware of, Your Honor. But I think there's a reason for that, and I think it goes back to the language of the statute. And the relevant portion of the statute is quoted on page 13 of our answer brief. In the language of the statute, the legislature gave the agency the ability to balance those 7 public interest test factors. So if you look at 1800 and you look at Florida Power, those cases say it's within the bailiwick of the agency to balance those factors. And I think it's because the courts realized that the agencies have the expertise to look at nutrient reduction, to look at flood control and protection. If you look at the trial transcript, we have professional engineers on staff. We have environmental scientists on staff that were experts in our case, and those are permit reviewers. So there is a degree of expertise involved when the district or other agencies are balancing these public interest factors, and that could be the reason of the only mention of it is in DOA cases as opposed to a district court case.
Ms. Quiggle, do you believe that if the ALJ found that there was no adverse impact with any of the 7 criteria, that there's any other scenario under which the ALJ could reject the request for permit?
If there were no harm,
If there was no finding that any of the 7 criteria or there was an adverse effect applied to each of the 7 criteria, do you believe that that by default would mean the ALJ would not be, it would not be appropriate for the ALJ to reject or deny the requested permit?
each case needs to be looked at on its individual facts. Here, it's an interchange project. There is concerns with water quantity and water quality, so it would depend on the facts of each project. But 1800 speaks to that, and I think it says that the denial of a permit really should be the rare exception in cases where there's extreme damage to the environment that cannot be avoided or mitigated.
But ultimately, the ALJ is to apply what amounts to a subjective standard and applying all of the factors. Is that correct? Even if the ALJ finds there's no negative impact, the ALJ could still come back and say it's not within the public interest or very clearly within the public interest, correct? Or do you think that that is totally not even an option once those findings have been made?
Oh, we're not trying to create a bright line rule, Your Honor, that if there's no harm that automatically meets the clearly in the public interest test. That's not what we're trying to do.
But you're also saying that when there's no finding of a negative impact and you have these additional factors, that to you seals the deal that there should be no denial of the request for permit.
It's hard there can't be a bright line rule because each project is different and the 7 factors are different. So when it comes back to the agency to weigh and balance the 7 factors, it's very factually intensive. Here, we took the findings of the ALJ and we plugged them into the factors based on the facts of this project. Let me give you an example. So factor 3 is navigational hazards. If you had a project that was built, say, in the Intercoastal Waterway, that factor 3 is going to weigh more heavily in that type of project than it would in this type of project. So the agency's role is to look at the factual findings, consider and balance those findings as they're plugged into the public interest test, those 7 factors, and then determine on balance if the project is either not contrary to or clearly in the public interest test.
But hypothetically, if none of the 7 factors weighed against issuance of the permit, would there be any opportunity to deny the permit? That's what I hear. That's what I hear the question presented as, and I certainly don't want to speak for Judge Wallace. He speaks very well for himself, but that seems to me to be a very good question. If none of the 7 factors weigh against issuance of the permit, is there discretion on the ALJ's part to reject issuance of the permit?
It's hard for me to answer a hypothetical, but I would say if there's no harm and there's not a greater degree of reasonable assurance provided in your hypothetical case, it would be a little bit harder to meet the clearly in the public interest test than it would be to meet the not contrary to the public interest test. I'm sorry if that doesn't answer your question.
No, that's
Okay.
fine.
Anything further? Okay, we ask that the court affirm the district's final order.
Thank you. I believe you have 2.5 minutes.
Thank you, Your Honor. One of the things that, since they were so heavily relied on the 1-800 Atlantic case, one of the things that's in that case, which is significant, is that the court there said essentially that the district has no authority over the public interest test. That's not, they have no special expertise in that. They're allowed to do regulations regarding water quality standards, but when it comes to the issue of the public interest test, they have no special expertise in that weighing and balancing. You know, they can't really, the ALJ hears these kind of cases on a regular basis, and you hear this language like a greater degree.
Well, it sounds like, again, you're asking us to defer to the ALJ.
I'm not asking you to defer
Well,
to the
that's
ALJ.
actually what you just said.
No, no, I'm not asking you to defer to the ALJ. I'm asking you to look at what the ALJ said and look at the conclusion they reached and how each of them went about arriving at their conclusion. And for you to then, for this court to then determine that the ALJ was more reasonable in the way he went about doing that than the district was. And based on that,
Does it matter in that analysis that he or she does it every day? Making our evaluation of that?
okay, I don't know enough about these kind of cases. I'm kind of new to this environmental stuff, but he does have, I guess, quite a lot of experience in this. I saw old cases where he was doing it, so yeah, he knows a lot about this. And they do send these before the ALJ so that they can have him determine disputed issues of fact. And so this court needs to look at it. He after doing everything, whatever he came up with, and he pointed out in his when he was weighing this stuff that a good portion of the evidence was elicited during the Derek LaMontagne's cross-examination. So there's limitations on what he can put in findings of fact, but he was looking at the overall picture. And essentially, he didn't see this, oh wow, this is clearly in the public interest. It just didn't hit him. And, apparently it did hit them. And he obviously, since he knew the improvement in the phosphorus, it wasn't overwhelming enough for him to say it takes it from not contrary to the public interest to clearly in the public interest. And, that was his assessment after 5 days of listening to a highly contested case.
Thank you. I believe your time's up.
Okay, thank you. Your Honor. Thank
It
you.
was well presented on both sides. As I told you in the